the truth's too loud to teach, so they tape the mouths they fear will preach. Land of the free but chained in speech, shadows stretch where the brave can reach. Facts cut deeper than a lie. Truth don't care if you comply. Scream it loud, let the silence shatter. Facts over feelings, that's what matters. Raise your voice till the walls start cracking. Freedom speaks and rebellion's happening. They sell you comfort to keep you blind, feed you the fear till you toe the line. But history's written by the defiant kind. Words are bullets when the truth's confined. Stand or fall, don't fake the fight. Freedom's born in the dead of night. Scream it loud, let the silence shatter. Facts over feelings, that's what matters. Raise your voice till the walls start cracking. Freedom speaks and rebellion's happening. Stand or fall, don't fake the fight. Freedom's born in the dead of night. Freedom's born in the dead of night. Scream it loud, let the silence shatter. Facts over feelings, that's what matters. Raise your voice till the walls start cracking. Freedom speaks and rebellion's happening. Happening.
Hello. It's been a little bit. I hope everybody's doing well and the sound is all right. I do have a little bit of a fan on, so I do apologize if there's a little bit of background noise. Today we are going to go over the First Amendment, specifically where it concerns freedom of speech and freedom of expression. I'll be bringing up the relevant case law that has determined what's considered protected speech, and the difference between speech and conduct, that type of thing. And we'll have one small side quest where we will be talking about parody, satire, and copyright, as well a brief hint on the Communications Decency Act, specifically Section 230, and how it pertains to social media and the user. So I do know that Granny is still live. Unfortunately, I was unable to push this back, so I do have a schedule today. But hopefully, in those that are coming in, Music City Mom, I really appreciate you taking the time to stop in today. If you have any questions, put them in chat, or for those on the replay, please go ahead and put them in the comments afterwards. I'd like to take this opportunity to thank all the new subscribers that have come in. After the last live stream that I did receive a little bit of a boost in viewership and subscribers, and I do appreciate that. I appreciate that Granny had dropped my channel, as well as Nonsense. And I do believe Trisha or Jay, one of those two, had made mention that the stream was beneficial. If I've misrepresented a channel, I do apologize again. That was just from feedback. So we're going to go ahead and get into this, and let's go. The First Amendment: freedom of speech, freedom of the press, freedom of expression, right to petition the government, freedom of religion, and the freedom to assemble. As always, we have a disclaimer. Nothing in this presentation is to be taken as legal advice. This presentation is simply a visual guide discussing the First Amendment of the United States Constitution, providing case law, nuance, and scholarly input regarding the freedom of speech, the right to free expression, the public square, and the digital landscape. The laws in the United States are constantly being updated as technology, culture, and society evolves. What is on the books today may be updated tomorrow. Do your own research. One moment. I'm very parched today, so I may be breaking often for a drink of water. Freedom of speech, the right to speak. Freedom of speech is the right to articulate opinions and ideas without interference, retaliation, or punishment from the government. The term speech is interpreted broadly and includes spoken and written words as well as symbolic speech. For example, what a person wears, reads, performs, protests, and even more. The First Amendment protects speech even when the ideas put forth are thought to be illogical, offensive, immoral, or hateful. Are there any exceptions to free speech? Yes, free speech does have a narrow limitation, and that would be incitement. Speech that incites imminent lawless action is not protected. This means it can't be directed at causing immediate illegal activity. Fighting words, words that are likely to provoke a violent reaction from the average person. The First Amendment makes no categorical exception for false or misleading speech. Certain types of fraudulent statements fall outside its protection. The government generally can impose liability for false advertising or on speakers who knowingly make factual misrepresentations to obtain money or some other material benefit. Defamation. False statements of fact that harm an individual's reputation. The statement must be false, communicated to a third party, made with a certain intent, and cause harm. True threats, intimidation, harassment. A pattern of conduct that impedes. That's conduct. A pattern of conduct. Those are actions. That's a behavior that impedes on the rights of others. These are serious expressions of intent to commit violence that the speaker intended to place the victim in fear. Incitement. Brandenburg versus Ohio. The Supreme Court of the United States. The Supreme Court held the government cannot punish incendiary speech. This case has become the benchmark. True threats and intimidation. Virginia v. Black. The Supreme Court, and we'll have more details to follow in a later slide. I'm sorry. Hate speech. The term hate speech is often misunderstood. Hate speech doesn't have a legal definition under U.S. law, just as there is no legal definition for lewd speech, rude speech, unpatriotic, or similar types of speech or expression that people might condemn. The term often refers to speech or expression that the listener believes denigrates, vilifies, humiliates, or demeans a person or persons on the basis of membership or perceived membership in a social group identified by attributes such as race, ethnicity, gender, sexual orientation, religion, or other protected status. Speech identified as hate speech may involve epithets and slurs, statements that promote malicious stereotypes, and speech denigrating or vilifying specific groups. Hate speech may also include nonverbal depictions and symbols. In the United States, hate speech receives substantial protection under the First Amendment, based upon the idea that it is not the proper role of the government to attempt to shield individuals from ideas and opinions they find unwelcome, disagreeable, or even deeply offensive. Instead, the government's role is to broadly protect individuals' freedom of speech in an effort to allow for the expression of unpopular and contravailing opinion and encourage robust debate on matters of public concern, even when such debate devolves into offensive or hateful speech that causes others to feel grief, anger, or fear. Defamation, public or non public figure. The First Amendment's protections include the vast majority of speech and expression, but it does have its limits. These limits have been carefully honed over decades of case law into a handful of narrow categories of speech that the First Amendment does not protect. Defamation. The First Amendment protects false speech with very limited exceptions, including defamation and fraud. Defamation is a false statement of fact that is, 1, communicated to a third party, 2, is made with the requisite guilty state of mind, and that's important, and 3, harms an individual's reputation. To be defamatory, a statement must be an assertion of fact rather than mere opinion or rhetorical hyperbole, and capable of being proven false. As to state of mind, if the person allegedly defamed a public figure, he or she must prove actual malice, namely that the speaker made the statement either with knowledge of its falsity or with reckless disregard for the truth. A non-public figure need only prove that the speaker was negligent in making the false statement. Free speech and social media. I refer you to freedomforum.org. Full disclosure, I am not currently affiliated with the freedomforum.org. However, I was an administrator on the precursor of Freedom Informant Network. How does free expression apply to the internet and social media? This issue was first considered in the Supreme Court case of Reno versus the ACLU, where the Supreme Court concluded that the internet should be given the same full protection as print media of the First Amendment. Free speech exists even online. However, it is important to note that in general, websites like Twitter, Facebook, Reddit, YouTube, and others may make banning decisions based on individually posted content that are not in the best interest of their company, which would be their terms of service or community guidelines, or due to general disagreements with the political bent of the posters. Keep in mind that Section 230 protects the platform from what the users post on their service. Online speech is protected by the First Amendment. New mediums of communication, online speech is equally protected by the First Amendment, as there is no basis for qualifying the level of First Amendment scrutiny. that should be applied to online speech, and that is the Reno v. the ACLU, and the court case is listed right there if you'd like to research it further. Indeed, based upon First Amendment principles of freedom of speech and press do not vary when a new and different medium for communication appears, and that's Brown v. Entertainment Merchants Association, and that was in regards to video games. Free Speech Bench Guide, Constitutional Provisions. The First Amendment, Congress shall make no law abridging the freedom of speech. The First Amendment is applicable to the states through the Due Process Clause of the 14th Amendment, Virginia v. Black. The Constitution, Article 1, Section 5, is more protective than the First Amendment, sometimes. Freedom of speech, every person may freely speak, write, and publish on all subjects, while also being responsible for the abuse of that right. In some situations, examples, prior restraint on public forums, place, time, and manner restrictions, the Constitution, Article 1, Section 5, is more protective than the First Amendment. In others, the two have been held to be coextensive. State versus Arlene Flowers. Subsequent proceedings following the 2017 decision, Stutzman appealed to the U.S. Supreme Court. The U.S. Supreme Court vacated the judgment and remanded the case back to the Washington Supreme Court in 2018 for reconsideration in light of the Masterpiece Cake Shop versus Colorado Civil Rights Commission. On remand, the Washington Supreme Court once again unanimously ruled against Arlene Flowers in 2019, reaffirming its previous decision. The U.S. Supreme Court denied Arlene Flowers' petition for writ of certiorari, effectively ending the legal battle in 2021. And this case, in short, was the state versus Arlene Flowers. It was ruling against a florist, establishing that a business owner's refusal to provide services to a same-sex couple for their wedding on religious grounds constitutes discrimination under state law. The Bill of Rights changed the original Constitution into a new charter under which no branch of government could abridge the people's freedoms of press, speech, religion, and assembly. To find that the president has inherent power to halt the publication of news by resort to the courts for injunctive relief would wipe out the First Amendment and destroy the fundamental liberty and security of the very people the government hopes to make secure. No law means no law. The New York Times versus the U.S., the Pentagon Press Papers. First Amendment does not trust the government's benevolence. The First Amendment does not entrust to the government's benevolence the power of suppressing speech found offensive to some portion of the public. Instead, the First Amendment must rely on the subsequent safeguards of free and open discussion in a democratic society. Mattel v. Tam. In a landmark decision, the Supreme Court ruled against the government, allowing the newspapers to continue publication. The court's reasoning was that the government had not met the heavy burden of proof required to justify prior restraint on the press. The decision reinforced the First Amendment's strong presumption against government censorship, and that was the New York Times. And in context, that particular case was in reference to information that was published that the government was claiming was not in the best interest of national security. Mattel v. Tam was a landmark Supreme Court case that significantly impacted the relationship between free speech and trademark law. The court rejected the government's argument that trademark constitutes government speech and is therefore exempt from the First Amendment review. The ruling affirmed the principle that the government cannot ban speech based on ideas that expresses that it may find offensive. The decision has had a lasting impact on trademark law, particularly with regard to trademarks containing potentially offensive or controversial content. Going to take a brief moment and have a drink. Rude breathing space, rude, hateful, and insulting speech. Hate speech is protected by the First Amendment. Listeners' reactions are generally irrelevant. The fact that a speaker conveys a message which may be offensive to the listener does not deprive the message from constitutional protection. Hill v. Colorado. The First Amendment requires breathing space. In public debate, our citizens must tolerate insulting and even outrageous speech to provide adequate breathing space to freedoms protected by the First Amendment. And again, U.S. v. Cassidy. Overbearing, obnoxious, or rude people are not to be penalized by anti-harassment protection order statutes. Burchell v. Thibault. Specifically, the page number 522 highlights a point discussed in the case regarding the interpretation of the state's anti-harassment statute, the former RCW. The court in Burchell found that the statute is not intended to penalize individuals for being merely overbearing, obnoxious, or rude, but rather to protect those victims who are specifically targeted by the objectionable behavior. And again, behavior equals conduct. Ideas matter, even offensive ones. The hallmark of the protection of free speech is to allow free trade in ideas, even ideas that the overwhelming majority of people might find distasteful or discomforting. Virginia v. Black. Constitutionality of the prima facie evidence. However, the court invalidated the provision in the Virginia statute that treated any cross-burning as prima facie evidence of intent to intimidate. The court reasoned that this provision was unconstitutional because it could suppress constitutionally protected expression and blurred the line between threats and messages of shared ideology. Burning a cross can have different meanings, and context is necessary to determine if intimidation is intended. Again, back to context. I've got several presentations on context. If there is a bedrock principle underlying the First Amendment, it is that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Texas v. Johnson. The court reiterated the fundamental principle that the government cannot prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Courts must not stifle debate. Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and inflict great pain. Courts cannot react to the pain by punishing the speaker. As a nation, we have chosen a different course to protect even hurtful speech in public issues to ensure that we do not stifle public debate. Snyder v. Phelps. The Supreme Court, in an 8-1 decision, ruled that the First Amendment protected the Westboro Baptist Church members from tort liability for their speech in this case. The court emphasized that the picketer's speech, although offensive and hurtful, was on a matter of public concern and therefore entitled to free First Amendment protection. We're going to go ahead and take another brief break. I will be right back with you. Thank you for waiting, y'all. I appreciate it. Okay, anonymous speech. Anonymous speech is protected by the First Amendment. Fear of retaliation or ostracism. The ability to speak anonymously promotes the robust exchange of ideas and allows individuals to express themselves freely without fear of economic or official retaliation or concern about social ostracism. Undoubtedly, the most famous pieces of anonymous American political advocacy are the Federalist Papers, penned by James Madison, Alexander Hamilton, and John Jay, both published under the pseudonym Publius. It is now settled that an author's decision to remain anonymous, like other decisions concerning omissions or additions to the content of a publication, is an aspect of the freedom of speech protected by the First Amendment, McIntyre v. Ohio Elections Commission. Anonymous online speech is protected. Through the use of internet chat rooms, any person with a phone line, nowadays internet, fiber optic, or a mobile phone, can become a town crier with a voice that resonates farther than it could from any soapbox. Through the use of web pages, mail exploders, and news groups, the same individual can become a pamphleteer. Although the internet is the latest platform for anonymous speech, online speech stands on the same footing as any other speech. There is no basis for qualifying the level of First Amendment scrutiny that should be applied to online speech. Again, Reno v. the ACLU and Thompson v. Doe, the denial of an attorney's motion to unmask anonymous defendants. Public and private concerns. Speech on public concerns. Public concern speech deals with matters of public concern when it can be fairly considered as relating to any matter of political, social, or other concern to the community, or when it is subject of legitimate news interest, that is, a subject of general interest and of valid and concern to the public. The arguably inappropriate or controversial character of a statement is irrelevant to the question whether it deals with a matter of public concern. Snyder v. Phelps. Private concern. Examples of private concern include dissemination of a particular individual's credit report or perhaps a government employer regulating videos of an employee engaging in explicit acts. In Snyder v. Phelps, the Supreme Court of the United States affirmed the Fourth Circuit Court of Appeals decision to reverse a district court judgment. The court held that the First Amendment protected the Westboro Baptist Church picketing of military funerals. The concept of private concern is central to understanding privacy rights and the legal protections afforded to individuals. A private citizen versus a public or limited public figure against unwarranted intrusion or disclosure of personal information. It's very important when you're a public figure or a limited public figure, or when you represent yourself or put yourself out public facing, where you want to gain, say, a following or to obtain sponsorships, have advertising. When you monetize yourself, basically, you become essentially a limited public figure until you reach perhaps a certain level of an influencer or online celebrity. Um, it's it's a fascinating concept because anybody with an internet connection is free to speak. Now, what makes a limited public figure versus maintaining your private citizenship type of situation, or just being not in the public? Anonymity may be one. How often do you put yourself out there? Are you somebody that occasionally will be online and share some arts and crafts? Or are you somebody that's out there speaking on matters of public concern, such as news articles, um, real crime cases, political topics, celebrity gossip? You can see where there is a difference from somebody that is utilizing a social media platform to just vlog about their daily life versus somebody that is using their platform to make a living and is discussing topics that are of public concern. Public streets, sidewalks, and parks are protected by First Amendment. Excuse me. Public place, a public place occupies a special position in terms of First Amendment protection. Public streets and sidewalks, including in residential areas, are the hallmark of a traditional public forum used for public assembly and debate. Snyder v. Phelps. Collier v. Tacoma, the traditional public forum includes parks, streets, and sidewalks. The First Amendment remedy for unwanted speech. Look away. Simply avert eyes to protect sensibilities. The right to free speech includes the right to attempt to persuade others to change their views and may not be curtailed simply because the speaker's message may be offensive to the audience. One reason the First Amendment tolerates vulgar language is because offended viewers can effectively avoid further bombardment of their sensibilities simply by averting their eyes. Cohen v. California. Impermissible to restrict speech where less restrictive alternatives exist. We are expected to protect our own sensibilities simply by averting our eyes when confronted with undesirable speech. Restricting speech when less restrictive alternatives exist is not permissible under the First Amendment. the U.S. v. Playboy Entertainment Group. Private person may infringe another's speech. The First Amendment does not prohibit a private person's infringement on another's First Amendment rights. It forbids any such infringements which may be attributable to the government. But private action may constitute government action where the state is significantly intertwined with the facts of the private parties. The State v. Noah anti-harassment orders. Moderation tools and social media. Block it. Blocking another from social media is permissible. In sharp contrast to a telephone call, letter, or perhaps an email specifically addressed to and directed at another person, one does not have to look at another person's internet bulletin board, nor does a Twitter or other internet blog user have to see what is posted on another person's account. That extends to YouTube, Rumble, Kick, DLive, or any other streaming service. This difference is fundamental to a First Amendment analysis. Unlike an email or phone call, one is free to disregard a tweet or blog, by extension, a video stream, chat stream, comment, or community post. An offended person has the ability to protect his or her own sensibilities simply by averting one's eyes from the speaker's blog and by not looking at it, or by blocking the tweets. U.S. v. Cassidy. 8,000 tweets received by two members of a Buddhist sect. Yikes, sorry guys, just a moment. The cat decided to knock my desk down. One moment. Are you guys still with me? Okay. All right, I am still streaming. Yes, I'm still streaming. Okay. The difference is fundamental to a First Amendment analysis. Unlike an email or phone call, one is free to disregard a tweet or a blog, and by extension, a video stream, chat stream, comment, or community post. Okay, we did go over that. I'm sorry. 8,000 tweets received by two members of a Buddhist sect, which included critical and disparaging comments causing substantial emotional distress, was confirmed to be protected speech under the First Amendment. Okay, the Communications and Decency Act. Section 230 embodies that principle that we should all be responsible for our own actions and statements online, but generally not those of others. The law prevents most civil suits against users or services that are based on what others say. Congress passed this bipartisan legislation because it recognized that promoting more user speech online outweighed potential harms. When harmful speech takes place, it's the speaker that should be held responsible, not the service that hosts the speech. Section 230's protections are not absolute, though. It does not protect companies that violate federal criminal law. It does not protect companies that create illegal or harmful content, nor does Section 230 protect companies from intellectual property claims. Section 230 protects all of us. For more than 25 years, Section 230 has protected us all, small blogs and websites, big platforms, and individual users. The free and open internet, as we know it, couldn't exist without Section 230. There are important court rulings on Section 230 that have held that users and services cannot be sued for forwarding email, hosting online reviews, or sharing photos or videos that others find objectionable. It also helps to quickly resolve lawsuit cases that have no legal basis. And now we're going to go on a little side quest. And thank you so much for being here. And I know this is going to be on the replay for almost everybody because there are other much larger channels live at the moment. So I hope you guys have found this information helpful and beneficial, and that, if you have any comments or questions, please leave them in the comments below. Parody, copyright, and free speech. Yes, the First Amendment protects free speech, including expressions of parody and satire to mimic and make fun of other artistic works or to criticize society. The First Amendment provides strong protection for artistic expression and for social and political commentary. Many comedy movies parody previously popular genres or tropes. For example, Airplane from 1980 is a parody of an earlier airplane disaster movie. Galaxy, Galaxy Quest from 1999 parodies Star Trek and other popular science fiction series. Black Dynamite from 2009 parodies the blaxploitation films of the 1970s. These and many more parody movies are all protected as free speech. Movies and literature are also satirize society, providing commentary through extreme exaggeration and fictional situations that shine a light on what the author believes to be political realities. The Babylon Bee and others lawsuit over California laws. In September of 2024, satirical site The Babylon Bee sued California over two new laws aimed at deepfakes. Because the text limits materially deceptive content, which the Bee claims could infringe on its free speech rights, California had enacted the laws in response to a widely circulated deepfake that used actual video of then presidential candidate Kamala Harris, but manipulated the audio, including having Harris say she is the ultimate diversity hire, a form of computer generated parody. In August of 2025, a federal judge struck down one of the laws, citing federal rules for online platforms. He also noted he intends to strike down the second law, this time for violating the First Amendment. Typically parodies rely on the fair use exception for copyright protections. Fair use enables creative works to draw from copyrighted material if they transform the work and do not copy too much of it too closely. Courts weigh these and other set criteria, including the purpose of the new work, in determining fair use on a case-by-case basis. The most important aspect of fair use test is whether the new work is sufficiently transformative by building on the original work in a way that gives it a new meaning. In the 1994 case of Campbell v. Ackhoff Rose Music, the court had to determine whether a parody version of Roy Orbison's Pretty Woman, Oh Pretty Woman by the rap group Two Live Crew qualified as fair use. It said that the parody is as much about expression as commercial gain. It further held that this particular parody demonstrated that it was primarily social commentary by starting with similar beats and lyrics as the original before departing into distinct sounds and comical lyrics that create new themes. I think this is important because there's been some issues raised or discussed about the AI songs that and the animations that are being made that are mocking or parodying certain creators on YouTube. Um, a parody is expression, and music is part of that expression. Even if it's mocking or offensive, it's allowed. Similarly, a parody or satirical work could face a challenge as intentional infliction of emotional distress. But this is a very high bar, and a parody or satire would be unlikely to qualify. Chief Justice William Rehnquist wrote in the Hustler opinion that parody and satire are meant to be offensive and may well cause distress, but that outrageous, severely distressing speech is indeed constitutionally protected when it deals with public issues and is said about a public figure. Let me repeat that. Chief Justice William Rehnquist wrote in the Hustler opinion that parody and satire are meant to be offensive and may well cause distress, but that outrageous, severely distressing speech is, indeed, constitutionally protected when it deals with public issues and is said about a public figure. He said that if the First Amendment, free speech, and free press protections did not apply, a jury could merely, on the basis of the juror's own tastes or views, or perhaps on the basis of their dislike of a particular expression, make a decision. The First Amendment prohibits viewpoint or content-based censorship or punishment by the government. Okay. I appreciate everyone that's going to come in and watch this later. Again, please leave a comment if you'd like. And I will see you guys next time. As always, I did set up a Ko-fi, which is co-fi.com/Wendy Blank, one word. If you'd like to leave a tip, channel support, or just pop over there to get updates on my channel and get exclusive first looks at upcoming live streams and personal projects that I'm working on off the internet. All right, we'll see y'all later. Around the next corner. Be well and joyful.